All right, good morning, council's interested parties. We're back on the record in the matter of State of Georgia versus Khalif Adams et al. In 22 SC 183572. Let me go ahead and take roll. Mr. Stillwell and Mr. Sharp, good morning. All right, Mr. Williams, Mr. Steele, and Mr. Adams, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Sr., good morning. All right, Mr. Nichols and Mr. Harvey, good morning, sir. And Mr. Ryan and Misty Williams, good morning. All right. Mrs. Brown and Smith and Ms. Love and Mr. Atkins, good morning. All right. All right, our jury is not present today. All right, just a way of housekeeping before we get to the main matter at hand. I received an email from Ms. Love, 2 emails this morning. First one was regard to the witness list that we're going to talk about in just a minute, along with an email, which I'll mark as the next court's exhibit in order, which references a YouTube link and may be used later to in the current examination of Ms. Archellen Bennett. I'll mark that as the next court's exhibit. And then also the next court's exhibit will also be another email that's sent by Ms. Love to all of you at 11:25. Well, that's the last night, I should say. I'm sorry. At 11:25 p.m., which references or summarizes the conversation she had involving Mr. D'Angelo White.
Not I, Your Honor. It was Mr. Atkins, but it's the same stuff.
Okay. All right. So that's marked as next court's exhibit in order. All right. And then, so to the matter at hand this morning, the state's witness list. So how many witnesses do you have on this current list? And it is enumerated from pages 1 through 12. I'll make that as the next court's exhibit in order for the purposes of our discussions.
Your Honor, inclusive of 2 names that were erroneously numbered twice, there are 209 persons on that list. There were a few persons who were added as a result of testimony that has come about over the past week regarding witness statements made in the presence of investigators and other personnel with the district attorney's office that we have included on here. These are people that we did not, we had no intention initially of calling in our case in chief, with the exception of anyone who's previously been listed on the witness list prior to now. For instance, Chief Investigator Randolph has already testified. We did not intend to call him back, except that the witness has made.
The witness, whom are you referring to in terms of the witness? All right, Ms. Bennett, okay.
She made statements to me. Ms. Bennett made statements in the presence of not only myself. I was never by myself when I spoke with her. So the persons who are listed that are somewhat new, Ms. Dos Reyes, I asked Ms. Bennett about the tall advocate with curly hair that spoke with her when she indicated that she did not wish to speak with me outside in the hallway. Lieutenant Baker, Hamilton, Randolph, and victim witness advocate Kelly.
Our witnesses we called already?
Yes.
I know we'll still be examining Miss Bennett and Mr., I should say, the retired Detective Quinn.
Yes.
So what's your net number of witnesses that you are planning to call?
That are remaining?
They're remaining, yes, ma'am.
209 minus 6. 153.
All right, and this 153 witnesses, you still believe and contend it's going to take 120 trial days?
Judge, what we did on our list is we gave a gross estimation based on the length of time that we have had to take with certain witnesses, factoring in both states direct, anticipated cross, and averaging out the way that certain witnesses such as Mr. Stevens, Ms. Bennett, Mr. Bean have gone in the length of time that they've taken, and applying that, overlaying that analysis over other similarly situated persons. Our very, very, very rough estimate.
Can we shut that
Has
door
the
back there if you wouldn't
testimony-
mind, please?
I apologize, Your Honor, I didn't.
No, could we shut the door behind you? There's sound is carrying, that's all. Thank you.
Factoring in the,
All right, so yeah, for example, so for Acts 5 through 7, if I'm reading your time correctly, you're saying it's going to take us from April the 8th to April the 10th.
yes, that's
Okay.
exactly how we've listed.
And that's your gross estimate? All right.
Yes.
Okay. All right. Then the next series of witnesses from April 9th to April the 11th,
Yes.
and then so on.
Yes.
Okay. All right.
And the longest ones, the court will notice, are 2 homicides that are on the list on our indictment. Those are the acts that we anticipate will take the longest amount of time to.
Okay. Has all of the discovery been tendered in respect to these acts that you are you're proposing on these particular dates? I understand these are gross estimations of how long it will take. So
And I apologize, Your Honor, I did not hear the court's full question.
and my thought was not complete. So have you turned over or tendered to make sure that the discovery that matches these particular witnesses has been turned over already?
Yes, Judge, we've
you scrubbed that again, and have you met with defense counsel, or are you assured that that all of the documents that are turned over have been turned over that are responsive to these witnesses? And what I'm asking is so that when the witness is called, and like I said before, if we have a situation where that document has not been tendered, or you can't tell me when it was given to the defense, if you tell me we gave it to the defense on February the 15th and it's in the same form, and they tell me, well, we haven't seen this, well, then we're just going to go forward. But if not, like I said, that's when I'm going to exercise several other options. So are you sure of that? Are you sure that you've tendered everything?
I'm fairly certain, and Judge, what we've been doing is prior to each of the acts, what we've been doing is sending over our exhibit list along with the witnesses that we intend to call for the upcoming weeks. So we will continue to do that. And if there was an oversight, error, or omission, not with respect to turning it over, but with respect to just alerting defense, we'll be using this exhibit in this act or with this witness, that I believe should cure any concern with respect to those issues. Because that's what I believe that's what we have continued, that's what we've done, and that's what we will continue to do.
The challenge that we've had is that defense counsel either says that they have not received that, okay, or it's an augmentation of something you gave them. So, for example, the discovery you gave them may have had 15 pages. Now it has 25. It's more complete. Or, as I mentioned a couple of days, yesterday, that you found something the night before from an Instagram search or whatever else of a particular witness, and you wish to use that. So that's what kind of, and then with the defendants, if you're going to, you need to be able to kind of state with particularity of what the state has not given you, and or I'm going to start asking why it hasn't been reduced to writing, because the older that, or the more you've had the particular evidence, or the discovery, I should say, the more I'm probably just going to go forward. So certainly, subject to, of course, exceptions.
Does Your Honor mean, for instance, reducing prosecutors' conversations with witnesses to writing? Or
no, ma'am, no. I'm saying what I'm finding is, like, for example, last week we had some telephone calls that I had to go through with you all that Mr. Steele brought up.
The text messages?
The phone, some, in terms of, I think it was Mr. Bean. We had the universe of maybe about, you all had told me you have hundreds and hundreds of calls, but relative to this particular period, you had about 10 calls that were relative to the inquiry at hand.
Right.
Well, 2 of them hadn't been gone through already, and I had to take up those in front, while the jury was sitting in a box. I'm not going to do that again. So what I'm saying to you is, if you haven't turned all those over, or the defense hasn't filed a motion in respect to that, we're going to go forward.
Your Honor, what we had done with those 10 calls, as the court, I'm sure, is aware at this point, we had turned over the 10 calls. We had spoken with defense about which ones we intended to use. We had, since before December, we had identified, and Ms. Hilton was able to actually locate the email wherein she told the defendants that we are using all of these jail calls right here.
Okay, but there were objections as to those jail calls, and I can't take those up while the jury's sitting in the box.
Right.
And that's what I'm saying to you is, my remedy is going to start being to exclude those calls, because I'm just not going to have, because we've had sufficient time to do that. So unless somebody files a motion or puts me on notice, remember I told you, happy judge, forewarned judge, happy judge, because then I don't have to take it up and have our jurors wait. I mean, and I'm not saying in any way I'm trying to limit your ability to present your case to either side, but what I am going to start kind of enforcing, pretty draconian in measure, will be if you all don't forecast the problems or issues you're going to have, then I'm just going to exclude it. Because I think that we've gone far enough down the road that you all are seasoned enough advocates. So if for example, you're going to use 5 calls, and the defense either has told you, hey, if they don't bring up something and they bring it up at the last minute, my remedy is to exclude it.
Your Honor, the problem is that we had, with those 10 calls, not only served them, not only announced that we were playing them, not only announced that we were playing all of them, but we had repeatedly asked from the defense, what portions do you object to? So we had satisfied all of our statutory obligations. We had even satisfied beyond that because we repeatedly requested of counsel for the defendants, which parts do you object to? And it was not until, and in fact, a motion in limine was filed as to one, but it was not until we tendered the calls that we had previously provided that the objection was made. So, Your Honor, we would of course object to exclusion of evidence.
I'm going to want to see that you had the I'm sorry. Let me let you finish. I'm going to go ahead and of course, it's subject to the reasonable test, meaning that if you sent the defense had conversations with them about it and nothing happened, well, then I'm not taking it up if it wasn't dealt with. Because somebody, like I said, I'm in no way saying don't try your case or don't bring challenges up to me so I can resolve them. I'm just kind of at a point right now where it's like, look, I can't keep taking it up in front of the jury. I got to be able to kind of deal with it in a more timely manner. Both sides have to allow me to do that. It's just not fair. It's not fair to this jury. We're going to have them here till well into 26 if we don't do that. So you can see my soon frustration in the sense that you all know what's coming up. Both sides, I'm going to add, I said, look, I mean, we can take a down day or whatever else and resolve some issues. That's fine. But that's kind of where I stand at this point in time. So do you understand what I'm referring to, Ms. Ms. Love? Okay. All right.
So, Your Honor. And we will continue and we will copy the court so that there is no question, there's no doubt about what we have provided when we are providing it, when we are announcing that we will be utilizing it. We will continue providing in advance of putting the information before the tendering the information, the exhibits that we intend to utilize with the particular witnesses, and we will inquire whether there are objections. We will do that so that it is announced to not only the court and counsel for the defendants, but so that the court is aware that there is no matter that we will be putting before them for the very first time when we do it with the witness, so that the court would not be automatically inclined to think it's something that they haven't seen. We have had instances where we've been informed that certain discovery was not had by counsel for one or more defendants. And we've had to go all the way back to June of 2022 in the first discovery that was served to show where it was. So we have had instances of those type of things happening, but beyond having found something very recently, we have not introduced or tendered anything that we have not previously provided to the defendants. The court made us very aware that we had obligations that we were to fulfill by certain deadlines, and we adhered to those, and we will continue to adhere to the court's directive. But there are I don't believe that the delays that have been that have come up during the course of the presentation of the state's case have had anything to do with the state.
There's, like I told you yesterday, Ms. Love, they're blamed to go around on everybody. Okay, that's why I didn't really need the argument yesterday. I really didn't, because I've sat here. So I'm not casting aspersions on everybody. Like I said, I want everybody to do better. And if you don't do better, I'm telling you, I got 5 remedies. Okay, so and you heard the remedies yesterday. I want to put them in administrative order. But I'm telling you as I'm sitting here right now, they were not enacted for me to be punitive or draconian to anybody. But I have the right and manner and obligation to control this trial. And right now, it's not going smoothly. So,
Your Honor, may I address something that the state has brought up? The state just made a representation that when they provided us the witness list, as this court ordered previously, that along with that witness list, they've been providing us with a list of exhibits. That's false. In the short time since that was stated about 10 minutes ago, I went back and looked at the witness lists that we were given on January 7th, February 9th, February 16th, February 23rd, February 25th, March 15th, and March 25th. And while we were provided that list of witnesses as ordered by the court, and I believe that the state was following the court's orders, those witness lists did not include lists of exhibits. Since she has made that representation, I would love to see that going forward. If we could get a list of the exhibits that they plan on presenting, along with which witnesses they'll be using those with, I think that that would certainly make this a more efficient process, Your Honor.
Your Honor, if Mr. Weinstein was looking only in the emails with the lists and not in other emails, he may have overlooked what the state has provided, but I am quite certain that we have provided in advance of our showing or tendering these exhibits, we have provided them to counsel for the defendants. And I can go through our emails and find those emails where we've done that.
That's great, Your Honor. If that's the case, I'm more than happy to hear it, and I would look forward to that going forward as well. And maybe if those were coupled with when we receive the witness list, we would get a spreadsheet with that list along with the exhibits that are going along with the witnesses. We could look at those exhibits in advance and maybe be better prepared to make this a more streamlined process.
And Your Honor, we have provided more spreadsheets than we could ever hope to get. And Your Honor, we don't intend to catalog our list. We did that initially with the acts that we intended to present, the witnesses that we intended to present per act when we provided the witness information. I'm certain counsel has resources available to do that for them, but we do not intend to do any more cataloging for the defendants.
I'm not asking them to do any more than they've already represented to the court that they have done. If you go back and look at the transcript from today, you will see that the state has said that when they provide those witness lists, they also provide a list of the exhibits that the witnesses
you
will be
did say that,
testifying
Ysl.
And I mean that, Your Honor, but I do not intend to go and provide spreadsheets. We will do it as we have been doing, which is providing emails that contain the witnesses and separate emails that contain the exhibits that we intend to introduce.
Well,
But
why
we
can't
do
you?
not.
Why can't you do both? Why can't you just make it simple? I mean, at this point in
Because
time,
Judge, it's just that we have no problem providing what we are intending to present. We've done that and we'll continue to do it. But Judge, this idea that we are the legal assistants and personal assistants of counsels for the defendants
saying-
who are
they're not
required
say-
to
they're not
put this
say-
in a spreadsheet and present
they're
it
not
to
saying
them.
that, madam. They're not saying that. But the problem we're having is that you are identifying, or you're not, I'm sorry, whether or not you are or not, but I'm gonna deal with that in just a second. The problem is that you may think that you identified some evidence, you haven't. That evidence is about to be tendered, or they're looking at it and they're like, well, this is the first we've seen of this. And well, that's what they're alleging, Ms. Love. I'm not saying that's true, okay? But that's what they're saying. And they're telling you, or Mr. Weinstein's telling you, if you marry the the witness and the evidence you plan on using, because at this point in time, like I said, there's no surprise. Your elected district attorney tried a gazillion cases in front of me. She turned over an entire file to the defendants, and her mantra was, if you can beat me with my file, then you deserve to win. Or if you can't, well, I deserve to lose. At this point in time, turn over everything. There should be no surprises at this point in time with identifying evidence and everything else that goes along with it. So what I'm going to do is two things. I want you to catalog these particular. I want you to, for each act and ban that you're going to present, I'd like you to add the evidence you're going to call. I want you to, because because here's the thing what will happen is, one, if they have an objection, they can put it in writing or they can file it early and I can go ahead and do with it, like I said. And if they don't, or you say, well, they say, well, we didn't give that to you. We provided that particular document to you in discovery on March the 15th. So you should have it already. At this point in time,
I'm saying just add to the list that we've already given you the exhibits we intend to.
I want you to add the exhibits
I can do that.
gonna present
I can
to
do
this
that.
particular spreadsheet. Will that suffice, Mr. Weinstein?
Thank you, Your Honor.
And also,
Streamline the process.
it might streamline the process because the challenge we're having is that, bless you. Counsel for the defendants are saying, this is the first time I've seen this document, or we haven't gotten this document. It hasn't been provided in discovery. Or it's a supplementation of the original document you gave them, meaning that they got it on that date, but instead of the document being 15 pages, it's 45 because it's complete. So that's why I'm saying that it causes them a little bit of anxiousness in terms of trying to be prepared. So, and it'll just further validate or verify, okay, we gave you everything, and it lessens the amount of time I got to spend resolving these particular issues. Like I said, you all are more than capable, and I'll give you the time and effort, but it needs to be better presented and packaged.
And
So,
Your Honor, we can do that. And with respect to the exhibits or evidence, I don't anticipate that we will be getting premature objections to certain things before we had the opportunity to lay a foundation. I could foresee us saying that we're going to introduce 12 exhibits for Act 29 and the defense objecting to it as, you know, hearsay, foundational or something before we've even had an opportunity.
well, I'm going to require them to put it in writing. I mean, so, but if you do this now, they'll be able to look at it and they'll be able to determine, A, do I have all the universal documents I need? And then two, what are the objections on it? Because I can't ferret them out. And I don't think it's fair to the jury or anybody else for us to be sitting here while I do that. I'm not going to do it anymore. The remedy at this point in time, I think for any appellate, or I could exclude it, and abuse of discretion is my grading mark stick. So at this point in time, if you want to make sure that you get all your evidence, at least in the sense that it is looked at or ruled upon by this court, they need to make sure that they have all of it so they can go ahead and do that. Now, if you've turned it over and it's now this period of time and they haven't filed a motion, then I'm just gonna continue at this point in time. I mean, I'm just gonna overrule the objection. We're gonna go on. We're gonna go forward because then they had the time and you told it to them, you gave it to them. So I'm just telling you this point in time. Or, like I said, I'm gonna suck up your weekends. If it's that important, then we'll come in on the weekends and we'll resolve it. And I've already checked with the sheriff. And we can do that, and that will not be a problem. So I'm not looking to do that because that takes my weekend up and my time off, along with my staff and everybody else. But I have got to get this thing moving, and we've got to be smoother and better, as advocates in order to do that. So I know that many of you may be annoyed, but hey, do better. So, Ms. Love, when can you augment this list? Can you augment it by tomorrow?
No, Your Honor.
When can you do it by? You should have a handle on every piece of evidence you probably have.
We do. The court is asking for something very specific, and so our resources, we would use them to give them to the court. For instance, for next week, we could have those done for the next 2 weeks. We could have those done
By when? Tomorrow?
by Judge, if the court.
I'm telling you,
That would be great, but if the court.
You got other
if
stuff
we
you
do it
need.
by tomorrow, then that's what we do. But Your Honor, we we'd ask that we not be required to go through and with respect to all of the acts.
Ms. Love, you must act like I was never a trial advocate. I know you all have this stuff together already, and if you don't, I'd be highly shocked. You probably have all this stuff together already. I mean, so just put it on paper and give it out so we can go ahead and go forward. It is not giving your trial strategy. The facts are what the facts are. I'm just sorry. Mr. Sharp, you find something funny with what I just said? Okay, all right.
I'm not doing anything abnormal. Just sitting here listening and paying attention.
Okay, all right. So, in that respect, there's nothing that should be a surprise at this point in time. Friday morning, that's when I want it. We already have a motion to Friday morning by 10 o'clock. I want to see it.
Yes.
Actually, no, because you all have off on Friday. So that's why I want it Thursday, ma'am. I want it Thursday because I want to take up your motion. I told you I'd at least give you a day. That's why I want it Friday morning. That's why I want it Thursday morning. So I'm going to listen to your motion, the motion to disqualify, and I'm going to make sure the next 2 weeks of, that means all the witnesses you plan on calling by the 19th of April. I'm also requiring that all counsel copy myself and Mr. Kearns, Ms. Weaver, and me on future correspondence going forward. Because I want to just see what is being sent to each other in terms to satisfy the court's directives as to evidence. And I want it sent, piecemeal, Ms. Love. I want it sent. At this point in time,
What?
in the future going forward, okay, I would like it to be sent, where you do the same thing you're doing with the court's exhibit or the augmentation of your witness list, okay? I want to be able to see what witness you're calling, what act, and the evidence that goes along with it.
Okay.
Okay? All right. Any defense counsel have any comment at this point in time? Let me cover Mr. Matthews. Anything you wish to add, disagree with about the court's instructions? So I'm looking for suggestions at this point in time. Mr. Weinstein, Ms. D. Williams, Mr. Harvey, Mr. Sharp.
I believe that you share this opinion, Your Honor, but I just want to be clear. Regarding recordings, as I've stated, there are probably thousands of recordings. I'm pretty certain Your Honor does not wish to have us, and quite honestly, I don't want to do this, go through every recording and file particularized motions for every recording and discovery.
But I'm not going to do it in front of a jury like we've been doing before.
No, I understand.
I'm not doing that anymore.
I understand, but
Okay, so what is that incumbent upon you to do then?
Well, I'm going to reiterate the fact I completely understand that you want to be forewarned about issues. I'm just going to reiterate reality that unless the plan is to have us go through thousands and thousands and write thousands and thousands of particularized motions, we do need the pared down, and I believe that's what the state's saying, but I'm just reiterating, we're going to need the pared down list ahead of time when they seek to introduce recordings so we can file in a timely manner those particularized motions for those recordings. Because to just file particularized motions for every recording and discovery would just be to cast a net that is way too wide, and it would not be time efficient for anyone.
Okay, but you all know now, even though you have thousands of recordings, you do have an idea which recordings are relevant for a particular witness or a particular period, correct?
I would not agree to that. We have.
Why not at this point in time?
Well, because there's thousands of recordings.
Okay, but focus, okay? The thing I'm asking you at this point in time, if you know, for example, witness X is going to be called,
Yes.
and you pretty much know at this point in time, there may be 15 to 20 recordings that are relative to that particular witness.
It-
Are you telling me that you true or not true? Is that,
No, I don't believe that's true.
why would you say that's not true then?
Because that's why I'm saying in a timely manner, and I'm not even suggesting that the state hasn't done this. I'm just trying to bring this to the court's attention, and we need those specific recordings that the state plans to use to be identified to narrow the net, then we can file our particularized motions in a timely manner.
So unless the state identifies them, you haven't looked at them in terms of that particular time period of that particular witness's recordings?
As Your Honor has pointed out, this is a RICO conspiracy. There's thousands of calls, and I can't believe, I don't believe that Your Honor is saying this, but there's hearsay.
I'm sorry?
There's hearsay.
Uh-huh.
There's inadmissible, there's third-party statements on every single jail call. And I'm certain that the expectation is not that we file motions on every single call in discovery. And Your Honor, I do not know what calls the state finds particularly relevant versus calls they don't. That they're putting on their case, and I cannot forecast their case. Yes, my client, for instance, Ms. Hilton sent me 5 calls in particular regarding my client's calls. And out of thousands, probably hundreds. And I am fully aware of those calls, and I'm not going to dispute that I'm on notice of those calls. All I'm stressing to Your Honor for the smooth administration is, to the extent the state has, that it continues, to the extent that they haven't, that it begins identifying in advance what calls they anticipate using to at least narrow it down so we can focus on the meat of this case instead of calls that they never plan on using.
All right, hold that thought.
Yes.
Here's the challenge, Ms. Lowe. Mr. Sharp may brings up a good point. Say Ms. Hilton gives the 5 calls, but instead of 5 calls on the morning, it's 8 calls. And they haven't identified or listened to those other 3 calls. That's what I got to take up. And that's what usually causes the issue.
We've not done that, Judge, and we've.
No, I'm gonna disagree, because that's happened on a couple of occasions, but that's all I'm saying. Mr. Sharp, do you have anything else? So you want them to keep identifying the calls and whatever recordings they wish to do?
That is correct.
Okay.
Thank you.
All right.
Thank you for turning your mic.
Okay. All right, Mr. Adams or Mr. Steele?
I don't think we have anything to add to what was anything. We understand.
Okay. All right. All right, Mr. Weinstein?
No, Your Honor.
Anything else?
No, Your Honor. Thank you very much.
All right. So, all right, and defense counsel, this is, I mean, I know that there's 8 terabytes worth of stuff, okay? But that in no way alleviates your responsibilities to, to listen to as much or to be prepared as much as you can. This should kind of help out in the sense of everybody kind of knows where they are, should be, at least where we're presenting or witnesses. Does anybody have any questions or issues with the witnesses that the state has identified? I know that they have identified the accident and
Your Honor.
sir, Mr. Sharp.
I would just like to forecast one issue, and I think we need to talk about this at some point before it comes up. I see that it's not scheduled until May. But witness 89, Sammy Davis, I noticed he is on the witness list. He alleges that he was at the scene at the time of the Donovan Thomas shooting. Your Honor has suppressed out-of-court identifications. I do not anticipate that he will make any in-court identifications. But I would like to have a conversation before he testifies with the court about the proposed testimony and what Your Honor would consider fair game without opening any doors by the defense to violate or to put in jeopardy your prior ruling. I think that there needs to be a discussion outside the presence of the jury.
When did I make that ruling?
I do not have the order.
Do you have a
in front of me.
copy of the order? Well, send that to Mr. Kearns, and I can take a look at it.
Yes, Your Honor.
I sent it to everybody, but you can send it to include Mr. Kearns and myself. Going forward, like I said, please include me on your correspondence so I can go ahead and at least be apprised of what is being sent or communicated between all parties, so I can be better informed. All right. Other than Mr. Davis, all right. Does anybody else have any other information or issues they need to bring to the court in terms of the witnesses that have been identified? We're going to add the documents that are to be called. What I'll do is, just like you said, you'll provide those by Thursday morning, and then the next
That's tomorrow morning. Your Honor.
tomorrow. Yes, ma'am. And I'll just indicate in my order that every 2 weeks the witnesses as well as the evidence list will be reprinted, or I should say will be disclosed for the next 2 week trial period.
Your Honor, as
Sir.
to whether any of us have any other issues with the witness list, just speaking for myself, as we just received the list 15 minutes before the 11 o'clock start time today, and I in no way mean to say anything negative about the state. I'm sure they stayed up quite late putting this together, if not all night. But I'm going to need more time to look over this list to see if I have any issues.
All right. Well,
Judge, this list is comprised of people with the exception of the ones that I named that.
4 or 5 that you've identified is the same
Right.
list that's been provided.
These names have been provided for months and months and months and months, maybe even a year. So if there are objections to these people, I would have expected that those objections would have been raised before now with respect to anybody on this list, because this list is a pared down version of the list that Your Honor has been, and we have all been working from for the last several months.
And Your Honor, I'm not going to, although I haven't looked at this, I'm not going to disagree that this list includes names or comprises names that have already been provided to us. I'll take the state's representation on that. All I'm saying is as far as any of these witnesses being a waste of time or cumulative, I need to really look at this list before I raise any issues with respect to that.
And Your Honor, with respect to the defendant's opinions about wastes of time and cumulativeness of witnesses, I know that the court is aware, and I'm certain counsel for the defendants are aware that the state alone has the burden of proof, and they cannot, the court has control over the order and presentation of the evidence. But I would think it quite presumptuous for a defendant to be able to assert to the court, when I'm certain he'll argue in the end, they didn't bring you this, or they didn't bring you that, or there wasn't enough evidence. I would find it quite presumptuous to argue that or presume themselves able to tell the state that a witness is cumulative or unnecessary when they will be quick to say and point out the fact of the matter that they do not have a burden of proof. We do, and we intend to meet that burden. And they are not able to, I would think, suggest to the court their best version, because I'm sure it would be much less than ours, of what witnesses we need to put up to prove what. And Your Honor, if we have 2 or 3 witnesses that testify about the same set of events, but from various vantage points, in no way could that be considered cumulative when, again, we have the burden of proof. And Mr. Weinstein's version of what's enough, I am quite certain will never equate to what I believe may be enough.
Well, I'll make that decision on a case-by-case basis, so that's part of my role and responsibility, so I'll take it up as it's presented. Okay, all right, anything else? All right, Ms. Love, by 5 today, and like I said, please submit a response so I can read it before tomorrow morning.
Yes, Your Honor.
All right, anything else on the witness list or anything? So we'll update the witness and evidence list. Mr. Kearns and I will work on an administrative order. And I will endeavor to enter that tomorrow. And so my goal for tomorrow is just for us to take up this motion to disqualify, and that's it. I don't think I have anything else. Is there anything else I missed? Councils? Yes, Mr. Steele.
Good afternoon, or good morning. Good afternoon.
All right, sir.
Your Honor, there is a matter that we'd like to take up with this honorable court, ex parte on a sealed record at the appropriate time today, if you don't mind.
Okay.
Thank you.
All right. Okay, I'll take that up as soon as we're finished. Okay. All right, anything else, councils? Other than the ex parte matter? All right, if not, I will see everybody tomorrow morning, the 4th of April, for 9 o'clock, okay?
Yes, Your Honor.
All right, we'll see you then, okay? We're in recess.
Thank you, Judge.
All right.
third one. I had wet hair. My hair was hanging down. I was looking down. I wasn't focused on other people. I was focused on getting this man away from everyone else.
So this man.
This man, Nikolai, knew.
Yeah, this man, at that point, you knew he had been punched and knocked to the ground and he's in the water, correct?
Yep.
And you're telling the jury that what you were trying to do is you were trying to get him away from other people while he's down in the ground in the water.
Get people away in some way, shape, or form. It didn't need to be him. I wanted him to stay down so he couldn't go and punch another person. And then I was going to tell everyone there to back away because, you know.
So there's a lot to unpack there again. As you said, you wanted to get other people away, but you didn't go to the other people. You went to Mr. Mew, correct?
Yeah, I went to the guy who was punching people first.
Correct. Again, based upon your memory that he pulled someone's hair and punched them from behind, correct?
Based on the memory that I know that he punched someone, yes,
Okay.
it doesn't matter how he punched them. I know he punched them and he shouldn't have.
Okay. And you were going to make him pay for that.
No,
So when he's down in the water on the ground and you're standing there trying to be the peacemaker because you're not a fighter, you thought it was going to be peaceful to you to keep him down in the water?
I mean, it was shallow water. His head wasn't below. All we needed was an extra second to get people to move away from him. And then he could get up and we could possibly have a conversation. But I mean, he hadn't used any words up until that point. So probably not.
So when you're standing there next to him when he's on the water, you don't see your friend Dante come up and smack him across the face a second time. You don't see that.
I saw him get dropped into the water and I was looking down at him. My hair was over my eyes here. I mean, it was shorter than it is now, but you can imagine.
So you didn't see him go back into the water the second time in response to Dante hitting him. You didn't see that?
He went down into the water and then he never got up.
Sure, because Dante
Until
hit him when
he-
he was in the water, correct?
Okay, but you said the second time he was in the water. That's the first time still. The second time came after he stabbed me.
Okay, understood. His first time was in the water was extended for a longer period of time because Dante smacked him when he was already down in the water.
Sure, yes.
And you're saying you were standing right there, but you didn't observe that.
No, like I said, my hair was in the way and I wasn't really focused on Dante. I didn't know where Dante was. I was focused on the man who was
In the
hitting
water.
people, who was hitting people, not.
At that point, the man that was hitting people was Dante Carlson, right?
Sorry, I will rephrase. The man who started the physical altercation.
Okay. That's what essentially your opinion is, correct?
I mean, I would say that the first person to throw a punch would be the first person to be aggressive, regardless of if there are other people slightly touching his shoulder. I mean, even you were talking about the consent to touch thing, and he touched other people without their consent too. So, I mean, if you want to go that way, we can, but it just doesn't make a lot of sense.
I'm not trying to go anyway, sir. I'm just trying to gather the facts. So the person that's punching Mr. Mew, you don't see that, correct?
I saw Mr. Mew fall into the water, and I didn't see anything after that in terms of him getting hit.
When you saw him fall in the water, you went up to him from behind.
No.
I apologize, but I'm going to need to show some
Yeah,
slides.
I mean, I can explain what I did.
It's good. I'm going to just go through some slides. Please show my screen, please. Showing you what's 2705. That's Mr. Mew in the water, correct?
Yes,
That's Dante Carlson swinging to hit him, correct?
and my leg in the bottom.
That's your leg in the bottom, correct?
Yep.
You're moving towards Mr. Mew, agreed?
Yes. Moving at him from what would be his front left side.
And then eventually you come to be behind him, correct?
When I would still say I'm at the midpoint of his body, he just sat up. That wouldn't necessarily constitute being behind someone. I mean, yes, I was, I guess, technically, but he wasn't there when I walked there. He moved himself to have me behind him.
You moved yourself, correct?
No, he moved. I moved, I walked over there, yes, but I was standing right at about his hips and then he stood or sat up.
So is it your testimony that in some way Mr. Mew was aware of your presence and intentionally turned to have you behind him? Is that what you're saying?
I'm not saying he did it intentionally. I'm just saying that that's what happened.
Okay. So again, you're behind him, correct?
In sort of on a side until he
This
starts.
is you with your left hand on his back shoulder
Yeah,
and his
but
right hand on his back shoulder. You're behind him, correct?
I have both hands on one shoulder. I'm not completely behind him. You can see I'm somewhat on the side, but yes, I am somewhat behind him due to his repositioning.
You're pushing him, correct?
Yeah, that's where I had said that I thought I'd push him in the front left shoulder to keep him down, but I was there too late, so I didn't get that shoulder. I guess I got the back of it, and
You said you're a peacemaker, right? You like to mediate?
yeah, that's what I was trying to do.
You can understand how somebody who'd been down in the water and hit 2 times, getting pushed from behind, may not understand that you're trying to mediate. Goes to his mindset.
Overruled. You can answer the question. If you're able to.
Sorry, what was the question?
Sure. As somebody who likes to mediate and was attempting to mediate, you can understand how a person in Mr. Mew's position who'd been hit twice in the water might not understand or appreciate your intent to try to de-escalate by pushing him in the behind.
I
You might
guess
misunderstand that, right?
he could misunderstand that.
Sure.
I mean, could have been solved if he tried to use words at all too.
Could have. And let me just go from 2745 to 2747. Do you see that? That's you still, that's your body behind him, correct?
Yes.
That's your right hand on the right side of his back, correct?
Yeah.
That's your left hand on the left side of his back, correct?
I'd say right's more in the middle, but the left one is definitely on his left shoulder.
And that's your roommate's brother, who is your friend Dante Carlson. That's his hand that we can see underneath your underarm there that's hitting Mr. Mew, correct?
Like I said, I didn't see it, but the video showed it. So I mean,
So your
based off of memory, I can't say yes.
Okay. Your face is right there, and you're saying you didn't see Dante hit Mr. Mew there.
No, like I explained, my hair was down in front of my eyes. It's wet. My hair's thick and black, so it's not super easy to see through.
What you did say is Mr. Mew wasn't saying anything. You could agree that in this position, with somebody pushing him from behind and somebody hitting him in the front, it might be a difficult time to use your words to make peace.
Yeah, the right time to use your words would have been before he punched a woman in the face.
We can get to that later. You extend your body in an attempt to push him down, as you say, correct?
Well, I was pushing down and then he got up and I fell forward. So
I was asking about your intent. Your intent was to push him down in the water, agreed?
it was to push his shoulder down so that he stayed down and I could tell everyone to back up. Yes.
So you agree, your intent was to push him down and keep him in the water.
To keep him down. If the water, I mean, if the ground was there, I would have done the same thing. I wasn't worried about there being water or not. It was shallow. His head wasn't going below. He was going to be okay.
You can understand how perhaps somebody in the position getting pushed from behind in the water might not appreciate that you were trying to protect him and keep him okay, right?
I
Is
guess.
his head appear to be getting wet there?
Not his face. That's where your mouth is. I see maybe the right cheek dip in a little bit, but as soon as go a few slides further and you'll see his head sit back up again.
Sure. Safe as can be, right?
I don't know.
It is. Yeah, please, let's focus on the facts. Clean Q&A, please.
Just back up a little bit more here. When you said his head didn't go in the water. Fair to say that's his head making a wave, correct?
I would say that's his back making a wave and his
Okay.
head still not in the water.
Have you ever fallen back after getting laid out in the water like that?
Yeah, I have.
Did it feel like maybe the water was coming up on you even if it technically didn't?
No, I mean, water usually has a pretty distinct feeling on your skin. I mean,
And when you had that experience where you got laid out and fell back into the water, did someone come up and attack you a second time in that situation?
Sustained.
So I'm going to go forward back to the position where we were before. I apologize. So again, you'd said here at 2754, you're attempting to keep him down and he manages to move away from you, the person who's pushing him somewhere in the back area, right? Yes?
yes, I was trying to push him in the front left shoulder and I got the back left shoulder.
Sure.
Because he was getting up and I was not fast enough to get the front left shoulder.
And I'm going to go through some other photos here that might be difficult. Are you okay with that?
Yeah.
In this position now, that's you in the yellow shorts, correct?
Correct.
And to your right is Dante Carlson, correct?
I believe so. I don't know. I don't remember seeing anyone else there. I remember pushing down and feeling strange.
Sure. Is this person, you knew what Dante looks like, correct?
Yes,
Is that Dante in the two-tone gray shorts with the Truly in his hand?
I believe so. Yeah.
And then that's the same person that's legs are right there, correct?
Correct.
So you and Dante are standing very near Mr. Mew as he's beginning to try to get up out of the water, correct?
Correct.
And as he begins to get up out of the water, you move towards him, correct?
Yeah.
You didn't know that he had a knife, correct?
No,
You were going at him, correct?
I don't know. I don't remember anything
Okay.
after
You're,
the first push.
this is where you're trying to, you push him down again, correct?
I would say we kind of attacked each other at that one, if anything. But I mean,
Okay.
I don't remember this, so I can't
Okay.
tell you.
But you're,
I didn't. He got me before I did anything to him. So
this is your hands on him, agreed?
okay, maybe my hand is on his arm. Yeah,
This is you, as you said, attacking him, correct?
I didn't mean attacking. Sorry.
Those are the words that you used to the jury, is
I mean,
you were attacking him.
I wasn't attacking him.
Okay. You were trying to push him down in the water.
I was trying to separate or get him isolated so that we could separate everyone else from him, so we could get everyone away and then we could figure out what was actually going on. Because you hear teenagers asking for help, you hear people yelling that he's a whatever, and I mean, at that point, and you see my